I'd like to thank everyone for attending this executive briefing on the Final VAWA Rules. This executive briefing is brought to you by Campus Answers, the Higher Education Division of Workplace Answers, and your presenter is Daniel Carter. Campus Answers is proud to offer the most compelling and interactive online compliance training solution in the industry. We bring cutting-edge courseware, the latest training applications together with a dedicated professional services team to provide and transform the way you educate your campus. Today's presenter, Daniel Carter, has been at the forefront of advancing campus safety and victims' rights for over 20 years. He began his career in campus safety at University of Tennessee, Knoxville after an on-campus murder. Mr. Carter graduated with a BA in political science and went on to work for Safe Campuses Now and then the Cleary Center for Security on Campus. Currently, Mr. Carter serves as director of the 32 National Campus Safety Initiatives, 32 NCSI, for the VTV Family Outreach Foundation, a national nonprofit organization created by a majority of the families and survivors directly impacted by the April 16, 2007 tragedy at Virginia Tech. He also serves on the Serve Justice Board of Directors. In 2008, Mr. Carter was recognized on the floor as the U.S. House of Representatives U.S. House of Representatives as probably the leading person in the nation in advocating more action and tougher action against crimes that are committed on campus. He also received the first Jean Cleary Campus Safety Award in 1994 for extraordinary things to make college and university students safer. Through his work, Mr. Carter has helped to develop secure passage of and craft the regulations for 7 major pieces of federal legislation, including the Jean Cleary Act, Disclosure for Campus Security Policy and Campus Crime Statistics Act in 1998, and the Campus Sexual Violence Elimination Act in 2013. Additionally, Carter is a widely recognized public speaker on campus safety issues in the national media, including on the CBS Evening News, MSNBC, NPR, and Time Magazine. And he's taught several dozen Cleary Act training classes to thousands of higher education professionals. So without further ado, I'd like to turn this executive brief over to your presenter. Please go ahead, Daniel.
Thank you. The Violence Against Women Act reauthorization amendments to the Jean Cleary Act and the new final regulations, which were published on October 20th, reflect the most sweeping change to federal campus sexual violence policy in 20 years. So there are some significant changes that colleges and universities across the country are going to need to be aware of going forward. And I'm pleased to be able to offer this summary, having been involved in helping to craft the legislation and the final regulations as part of the negotiated rulemaking committee. Here are several of the highlights from the final VAWA rules. There are modernized definitions of sex offenses which have long been reported by colleges and universities, but there are some changes to how they will be reported beginning with the 2014 statistics. The definitions of dating violence, domestic violence, and stalking have been clarified. One of the biggest changes in the final regulations from the proposed regulations that were published over the summer was the addition of an unfounded crime reporting category, this is a brand new requirement. The final regulations also does prevention and awareness education requirements, student and employee rights when they report an incident of dating violence, domestic violence, stalking, or a sex offense, as well as how disciplinary proceedings should be conducted in these cases. There are several important deadlines to be mindful of. The U.S. Department of Education has said that beginning with the annual security reports that were due on October 1st of this year, institutions had to undertake a good faith effort to comply with the statutory requirements of the law. So there are certain key things that were plainly in the statute that are not regulatory in nature that institutions are already being expected to do now. The final rules were published on October 20th, and they technically take effect on July 1st, 2015, which gives institutions until October 1st, 2015 to fully implement all of the guidelines found in the final regulations. So institutions have just under a year to begin putting steps in place to take care of complying with all of the final regulations beyond the good faith effort that had to be undertaken for this fall. Some major changes to how colleges and universities report sex offenses. Previously, colleges and universities used the term forcible and non-forcible sex offenses. And now, colleges and universities will report rape. And it's a more inclusive definition consistent with that adopted by the FBI in 2013. And it's defined as the penetration, no matter how slight, of the vagina or anus with any body part or object, or oral penetration by a sex organ of another person without the consent of the victim. And one of the key changes to this terminology is that now there can be same-sex rape. Under the old definition of forcible sex offense, that was still included, but it was included as a sodomy. And it is now called what it is. It is called rape, which is very important both for in terms of how incidents are reported, as well as for giving validation and vindication to those who have been the survivors of these types of assaults. The forcible terminology that was previously used for both forcible sex offenses and fondling has been removed and is no longer to be used beginning with calendar year 2014 statistics going forward, which will be reportable in the October 1st, 2015 annual security reports. There will be a completely separate listing as well for fondling, incest, and statutory rape. Previously, there were two categories of sex offenses: forcible sex offenses and non-forcible sex offenses, with non-forcible sex offenses being limited to incest or statutory rape, and there being a series of categories that were included in forcible sex offenses. It's now rape, fondling, incest, and statutory rape. And in one of the biggest departures as well from previous reporting guidelines, the U.S. Department of Education has exempted all sex offenses from the hierarchy rule, which typically requires an institution to report only the most serious offense in a multiple offense situation. As a practical matter, this means that institutions are only going to be reporting a sex offense in addition to another crime if it happens in addition to a homicide, which is the only more serious offense that would trump it in the hierarchy rule. And that is expected to be limited, but nonetheless a significant change. There's also the addition of what are known as the VAWA crimes, primarily because their definitions come from the Violence Against Women Act. That is dating violence, domestic violence, and stalking. And these three sets of offenses are to be reported separately from the main Clery Act statistics, similarly to how hate crimes have been reported for many years now. They're a separate bucket, if you will, of statistics. And dating violence and domestic violence are defined as being mutually exclusive. So if one incident occurs, it's not going to be reported in the other category. And stalking, while not specifically mutually exclusive, is a type of pattern of conduct offense that really works differently. It doesn't involve actual acts of violence. It involves threats. So it, as a practical matter, is also separate. One of the changes from the proposed rules to the final rules for stalking was that it's reported only once per pattern of conduct. And the proposed rules had said if there was an intervention such as a conduct action taken against someone found responsible for stalking, then if they continued the stalking afterwards, it would be reported again. The final regulations provide that stalking, a pattern of incidents, is reported only once per year. If it continues across multiple years, it is then again reported in the next year. And dating violence is defined as violence committed by a person who is or has been in a social relationship of a romantic or intimate nature with the victim. And during the November 13th webinar, we will have time to get into more details about that in terms of the professional discretion that must be used and the deference to the reporting party that is to be used. Domestic violence is a felony or misdemeanor crime of violence committed by a current or former spouse or intimate partner of the victim, a person whom the victim shares a child in common, or a person who is cohabitating with or has cohabitated with the victim as a spouse or intimate partner. And the Department of Education was clear in answering several important questions raised by commenters, that this does not include people who happen to be just roommates either living together in a residence hall or an apartment. There has to be that intimate or romantic relationship component in order for this to be a reportable incident and for it to trigger the rights and options that students or employees have when they report it. And stalking is defined as engaging in a course of conduct directed at a specific person that would cause a reasonable person, and the Department of Education has provided that it is a reasonable person similarly situated to the victim. So what a campus police officer or dean of students might consider to be likely to not put them in fear or to put them into fear is not the standard to be used. It's the standard that would put someone in the victim's place in fear. And it's whether it puts them in fear or not, that's the standard that's used. Or to suffer substantial emotional distress, and that's the definition. The most significant change from the proposed regulations to the now final regulations are the addition of reporting of unfounded crimes. Now previously, unfounded crimes, which means it's a report that would otherwise be included in an institution's statistics, so it was originally a good faith report, but it is one that has been determined to be false or baseless through a sworn law enforcement investigation, which goes beyond someone not being found responsible, a decision of a prosecutor not to pursue charges, the return of stolen property, means the incident never happened, and that there is a thorough law enforcement basis for. So this is something that a dean of students, for example, a determination that a dean of students could not have made. Previously, they were excluded from Clery reports, and there is a new requirement in the final regulations that requires institutions to separately disclose a list of all unfounded crimes for the 3 calendar year period that they're reporting for. And the purpose for this is to address concerns that some incidents may be unfounded through problematic means, and this provides the Department of Education, according to their notice, a method of helping to assess whether or not there's an issue with how crimes are being determined to be false or baseless at a particular institution and in general. The final regulations also require prevention and awareness programming for all new students and employees, and the final regulations talk about this being able to be offered either in person or electronically. And there can be a multi-faceted approach to how this is offered depending upon the type of institution, whether it be students or employees, etc. The Department of Education has explicitly said that while institutions do not have to mandate that they do a head count that all new students and employees participate, it must be available widely enough to sufficiently reach all new students and employees. And this is something that, were it to be assessed, would be assessed on a reasonableness basis. So it's important that this be a wide-scale type of program or programs offered to students and employees, and institutions may, according to the Department of Education, implement standards to require all new students and employees to complete their prevention and awareness programs. Institutions must also offer ongoing campaigns for students and employees that specifically address primary prevention, which is adopted from the public health model. You could think of it as inoculating against the disease rather than treating the symptoms, so that the cultures on our nation's campuses which have tolerated sexual violence are changed so that the attitudes that allowed them no longer tolerate this type of conduct. Awareness programs as well as bystander intervention being really the other new program which encourages campus community members to take safe steps to intervene when they see a possible incident of sexual violence that may be about to occur, such as quietly navigating someone out of a potentially risky situation, saying such as we've got class in the morning and helping to walk them home, etc. Students and employees are also now granted certain explicit rights. One of the most important is that these rights and options must be provided to any student or employee in writing when they make a report of a sex offense, an incident of dating violence, domestic violence, or stalking. And the rights include accommodations, and it includes rights for both students and employees. So, for example, if a student is in a class with a student who has either sexually assaulted them or has been accused of stalking them, then they have an option to transfer to another class section if one is reasonably available. Or an employee might have the option to request a safer working environment being transferred behind a door, for example. They have an estranged spouse who has been stalking them. And accommodations must be made available, again, if they are reasonably available and requested by the reporting party. Institutions must also disclose services and resources such as counseling services and medical services. And one of the other major differences between the proposed regulations and the final regulations is that specific points of contact for each of these resources for accommodations, counseling, and medical services, as well as for filing a disciplinary complaint, must be identified. So, for example, if students need to contact the Dean of Students office to request accommodations and employees need to contact the Human Resources office to request accommodations, then those points of contact by office and contact information and perhaps location must be identified. For disciplinary proceedings, the institutions must describe each type of proceeding that might handle a sex offense, an incident of dating violence, domestic violence, or stalking. So if there is a separate process for sex offenses, then that proceeding should be disclosed. If there are different proceedings, and there typically are for employees as opposed to students, then that separate process must be disclosed. So you may have an institution, for hypothetically, that has 4 different types of proceedings depending upon the type of incident and who is involved. Each of those types of proceedings must be disclosed and described. And it must include the anticipated timeline, and that's how the Department of Education will determine whether or not an institution has a timely disciplinary process. Now, taking into account Title IX guidance, Typically, this means that a case should be resolved within 60 days or less, barring exigent circumstances. And there are provisions in the regulations that upon notice to both accused and accuser, that an institution can extend the timeline, but they have to provide that notice and a basis for doing so. There must be a description of the decision-making process, must be a description of the standard of evidence. The policy must list all sanctions and range of protective measures, and both the accused and accuser have an unconditional right to an advisor of their choice. And the Department of Education has said that this does include attorneys. However, they have also said that the right is to an advisor, someone that speaks directly with the accused or accuser. So not necessarily someone who would be addressing the proceeding. Both accuser and accused are also entitled to simultaneous written notification of the outcome of the proceeding, notice of an option to appeal, if any, and a notice of any change in the decision based on an appeal. And those are unconditional rights that both accused and accuser have in these cases. So to sum up, we have a very significant body of changes to how colleges and universities respond to sexual violence. It's really based on what we've learned over the last 20 years of best practices and how to best prevent and respond to sexual violence in higher education. And it's really designed to work seamlessly with the best practices and to help give colleges and universities an important framework to make sure that these types of crimes are prevented and dealt with effectively when they occur.
Excellent. Thanks so much, Daniel, for a really great overview on what people need to know about these regulations. And thanks to everyone for watching this video. We hope that you find it helpful and informative. And please check campusanswers.com for more information on VAWA training, as well as many other types of training for your campus. Thanks a lot. Bye-bye.